Schlecke. Bill Schlecke is in the house.
Jackie?
Jackie Austin.
There you have it.
One of our special guests tomorrow on the show.
Oh, yeah. So, is it today, Jackie, or Friday and Saturday? Friday and Saturday are double point days. If you sign up for the Amazing Race as a team, you get double points. Now, there's two types of winners for the Amazing Race. There's $500 for the team that comes in first, and $500 for the team with the most points. So double point day is important. $80 per team. Go to fitnesscouncil.org. And the only reason I hesitate to say that is when I've gone there to sign on, I've had to go in to the website a couple pages to find it. So if you find it difficult, you can call us.
Now, are you and Bill in?
I can. I know all the secrets.
Oh, really?
And Bill is just going to be social candy, I guess.
You're
going to be the social butterfly.
I may be up north. I don't know.
He'll be the social butterfly
but no,
at the party.
I'm not participating in the Amazing Race. And Laura can't because she's the one who's actually setting it up.
Right. I know all the secrets.
Yeah.
So that wouldn't be fair. So you can call us at 780-3800 or go to thefitnesscouncil.org. Just know that that website's a little more challenging to navigate. At least that's what I found. Someone brighter than me may not have any problems. But that, it's totally possible. Right?
Give it your best shot.
That's right. You look like you have something on your mind, Phil.
Seriously? Other than work, you mean?
Well, I don't know what you have your computer here, and I don't know. I'm not used to that.
That's because I wanted to make sure I had two recent cases up in front of me before I said anything.
Oh, before I get further, we have the high heel bike ride is on August 19th too.
Well, I am participating. Greg, I'm participating in that.
Are you really?
I have a great set of high heels. Yeah.
16th.
Sweet.
Yeah,
August 16th. What did I say?
They're red. Okay. I also have a pair of purple pumps, but since this is a high heel race, I'm wearing the red high heels.
Are you stealing my shoes?
Yeah.
Could you get that on your website?
Which of the hundreds of pairs of shoes would I be stealing?
I don't have that many shoes.
Racers can get 10 points for participating in that.
Racers for the Amazing Race can get 10 points for participating in the high heel bike ride. This is a cute little card, Jackie. And that's August 16th, starts at noon at the Bucky Harris Park.
Okay.
And you have one in your hand, so I'm sure you're going to help us spread the word.
Absolutely.
And then we've got sign sponsors, and there's a lot of stuff happening on that Amazing Race. You better sign up. Well, you've got friends over there at Starbucks that should be signing up.
They're acquaintances.
I've got a shout out.
I'm sorry. I've been working on this huge project that's due in Illinois court tomorrow, and I'm a little punchy this morning.
Yeah, you are. You didn't take my mother coffee. You know how upset she's going to be.
I was going to give my mother-in-law a shout out, and I'll try and do it after I get off the air this morning. I'm going to try and get back to Starbucks and get a macchiato or whatever it is and take it to her. So to my mother-in-law and Barnett, I apologize I didn't get it out there before the radio show this morning. So
I've got a shout out. We're having our windows cleaned by Tim of the Window Wizard. Amazing job. It's like there's no window, there's no glass.
Wow.
He's doing such a good job.
The Window Wizard.
The Window Wizard. People should hire him.
Where does he come from?
He lives over there by Hickory Hills,
So he's
Tim Anowitz.
He's a local wizard?
Yeah, he's a local wizard. So good guy, very diligent, and early. He comes early to get the job done.
It's like having no windows.
At all?
Yeah. You can't tell whether the window's open or closed. All right.
That could be dangerous.
Yeah. So.
What do you want to talk about? You have something on your screen.
Well, there are two recent cases that were decided by the Michigan Court of Appeals. I'll let you take your pick. The first one is a case entitled County of Jackson versus City of Jackson. That would be the one of great interest to a number of clients of mine who develop and own commercial real estate, particularly throughout the state of Michigan. So that decision has some importance. However, since you're a city council person, I'm not sure you want to talk about this. I know that you weren't on the city council when the stormwater fee was adopted, but it's an issue obviously that city council will be addressing. So my recommendation as your lawyer is don't talk about it on the air this morning. Allow me to talk about it. And
Yeah, then people would be disappointed because they couldn't hear my voice.
yeah, right.
Uh-huh.
But at any rate, so that's one decision of actually very, very great importance to municipalities and to owners and developers of property because it involves the issue of whether or not a stormwater fee, at least as adopted by the city of Jackson, constitutes a true fee for service, or whether it's disguised as a tax in violation of the Headley Amendment. And the Court of Appeals held that it was a disguised tax. Set it aside. The interesting thing in that decision, several interesting things. I find it a fascinating decision. The Court of Appeals struck down the fee on a number of grounds, but an interesting side note to it, at the very end, they said that the city had to repay only the plaintiffs who had sued, so that the balance, the vast majority of property owners in the city who have paid that fee are not entitled to reimbursement under this particular decision. Now, what that means, I guess, is that all individual property owners could file their own lawsuits, or somebody may be able to certify a class of taxpayers, or fee payers rather, to commence an action. But it'll be an interesting thing for you and the other city council people to address.
Very interesting.
You get to do it in executive session since it is a lawsuit. You have the opportunity to appeal to the Michigan Supreme Court, or to let the ordinance let the decision rather stand. It'll be an interesting conversation in executive session for the city council, I expect. So I wouldn't want you to talk about it on the air.
It's a very interesting fodder for talk radio.
Yeah, very much so. And look, when Bolt versus City of Lansing was decided, which is the decision that's relied upon by the Court of Appeals.
Right.
I mean, you read it, and it's true. And I think a municipality has to be very careful in terms of adopting fees that weren't in existence before, but now municipalities looking for revenue adopt a variety of fees, whether it's stormwater fee or some other kind of fee. And there are two concepts here. One is the fee really disguised as a tax, or is it a tax disguised as a fee, rather? I said it the wrong way. And then the second question is, even if it is a fee, is the fee reasonably related to the services or benefits being provided to the property owner or the fee payer? And the court also addresses that issue. It is fascinating. The other decision that's a little more mundane, and I think is of interest, and it highlights property interests in the state of Michigan, is a case called Andrews versus Alter that was decided last Tuesday by the Michigan Court of Appeals, and it involved Pine Lake over in Oakland County. But since Jackson County has so many lakes, it has application here. It dealt with the theory of acquiescence in a boundary line. In other words, you have a legal boundary line that's surveyed, but the parties for a period in excess of 15 years treated a bush line, a different line as the property line between them. And so that was one issue before the court, and the court said that yes, because the parties had treated this line as the property line for 15 years, it had now moved so that the survey line was no longer the boundary line. But the interesting aspect of this case as well, the other interesting aspect is it involved the placement of a dock in the lake. And I've been involved in dozens of, probably several hundred lake cases, dozens of which involve disputes between adjoining lakefront owners and the placement of docks. I mean, I had one case where two neighbors were full-time summer residents. The other one was a weekend resident. The weekend resident put his dock in the spring, and it interfered with one of the neighbors. So during the week, that neighbor took the dock, the weekend guy, and pushed it over to the other side. So then the next week, the guy on the other side pushed it back to the other side.
Is that the one where the lake was on a curve?
Yeah, this is in Round Lake down in Lenawee County. And finally what they did is when the weekend resident was gone during the week, they simply pulled his dock out and put it back on the ground. So, I mean, it's an interesting...
That's where the judge actually came out to the site, isn't it? And looked at it?
Yeah, that case, yeah, we ended up with a judge coming out to the site. But, so anyway, so that's an issue that involved both acquiescence, adverse possession, and what's known as an easement by
Well,
prescription.
interesting on that property line is we're closing on a transaction next week where help me out here, Jackie, what was on the other property? Oh, the well was on the neighbor's property. So the neighbor gave the seller of the property 10 feet. And it was a good thing that the neighbor didn't have a mortgage.
Yeah, they
on
couldn't
their
have done it.
property.
Couldn't have done it with a mortgage. They also have to worry about setback, side yard setbacks.
Right, that and taxes.
Yeah,
So I would think that that would be true in your Bush theory.
You got a land division issue under the Michigan Land Division Act. Usually, where you're merging it with an adjoining parcel, you're not going to have an issue. You do have to get the approval of the municipality. But again, the issue is going to be side yard.
Well, if the municipality
Side yard
approves it, I assume they've looked at side yard setbacks.
Yeah, they would. That's part of the Land Division Act, is to verify that in fact you're going to meet all of the then applicable ordinances, including the side yard setback.
So if there's a mortgage on the property, the mortgage reason that's a problem is because of the
You'd have to go get the mortgagee's approval because
Of the legal description.
the transfer of the land would be depriving the mortgage company of 10 feet of its real estate securing the mortgage.
So what happens when a court comes down and says, you know what, the boundaries, those bushes, not what the legal description says, as opposed to a neighbor just saying, okay, yeah, I see your well is on my property, I'm going to give you 10 feet, and the municipality cooperates and everybody cooperates,
Right.
and there is no mortgage, but there may be a mortgage on this particular one. So how does that happen? Does the court force the mortgage company to?
Yeah, you raise a very interesting question. The first order of business would be if the acquiescence or the boundary line change by adverse possession or acquiescence occurred before the mortgage was put in place, then I think the mortgagee is out of luck. In other words, the mortgage doesn't apply to property that the person giving the mortgage didn't own at the time the mortgage was given. A little more difficult question to answer would be is if the 15-year period started, let's say, in the year 2000, and the mortgage was put on the property in the year 2010, and the 15 years ran in 2015, the question would be whether or not the running of the statutory period would extinguish the mortgage as to that, in this case, let's take 10 feet. I don't know the answer to that. That's an interesting question. My guess is that the mortgage would lose. Mortgagee would lose. But that's one reason why he has surveys done, so that people actually understand where the boundaries are, and then if the survey line is different from a fence line, or it's different from a bush line, or the way the parties have treated the property, then you address it before you have the sale, and you address it. That's why mortgage company often, let me back up a little bit. I suspect that the mortgage is going to lose unless the building encroaches across that line, but then you wouldn't have acquiescence or adverse possession. Because the building, if it's subject to the mortgage, it would be tough to claim adverse possession on the part of the adjoining
So what about that house over there in the Detroit area that has, 8 feet on the neighbor's property?
Right.
Or,
Right, the
that's a
expensive one on
big house,
Bloomfield,
I
right.
assume there's a mortgage on
Or
it,
West
maybe
Bloomfield.
not.
I don't know the answer.
Let's
If there is a
assume
mortgage,
there's a mortgage on it, and what's going to happen to that great big, beautiful brick house?
The mortgagee is going to lose on that one because the mortgage, when it's taken, has to have a survey done or has a mortgage survey done to verify that the improvements are entirely within the boundaries of the property. And there it wasn't a question of adverse possession or acquiescence. It was actually across the legal line, across the boundary line.
Or was it a setback issue? But either way.
No, I think that was actually across the line. I can't recall if it was strictly if it was encroachment or violating a setback. I thought it was an encroachment. Maybe not.
Hey, back to stormwater.
Yeah.
I can't comment.
Right. What do you want to know about stormwater?
Well, what's your feeling if the generally everybody that I talk to feels they need to be reimbursed by the city if the city does not pull that trigger somehow? Do you see a lot of individual lawsuits or attempts?
I don't think so, because the cost of bringing a lawsuit would exceed the amount that you're going to get. I mean, you got a filing fee, you got a lawyer, all this sort of stuff. But
Could you small claims it or no?
Yeah, I think you could.
Okay.
Yeah, you know, I didn't even think about that. You know, as a lawyer, we can't go into small claims court. I don't even think about small
Right.
claims. So, yeah.
Okay.
Yeah, that might not be a bad idea for a property owner. If the city doesn't step up to the bar, and understand, my wife and I may be on different, well, no, I take it back. She was quoted on your show.
Yep.
Uh,
But we have not discussed it, so
My-
as a
my-
city.
Right.
Look, I'm a firm believer in the rule of law, and whether, if you don't agree with the Court of Appeals decision, if you're the city or you're another aggrieved party and the Court of Appeals decides against you, you know, your option is to appeal to the Michigan Supreme Court. And then if the Michigan Supreme Court rules against you, that's generally the court of last resort, although if it is a federal constitutional issue, you can appeal to the U.S. Supreme Court, but good luck with that one. So essentially, it's the Michigan Supreme Court, and if the city council decides by majority vote that it's going to appeal to the Michigan Supreme Court, then everything's on hold. We'll wait to see what the Supreme Court says. If the Supreme Court reverses the Court of Appeals, stormwater fee stands. It's not a tax. No harm, no foul. The city keeps the money. If the Michigan Supreme Court comes back, though, and if the city decides not to appeal, or if it appeals and it loses, then it seems to me the rule of law is, even though these plaintiffs are the only ones who were ordered by the Court of Appeals to get paid back, I think the city has really an obligation, rather than sit back and wait for a whole bunch of lawsuits, but even apart from that, would have an obligation to follow the rule of law. Simply step up to the bar and say, hey, look, we made a mistake. It's in violation of Headley. This is the law of the land. We may not necessarily agree with it, but that's the law of the land, and let's do the right thing and pay back the stormwater fee. Yeah, they'll have a shortfall in terms of funds. They're going to have to work on that, but I guess that's what city government is all about, is to balance the budget. They're required to have a balanced budget, and work within the rule of law.
How expensive would that be to go the Supreme Court route?
I don't know. I mean, I've handled cases before the Supreme Court on occasion.
And would they hear it?
They have to grant leave to appeal, because it is such an important issue. They would generally, I say this,
They wouldn't have to hear it.
They don't have to. You have to
Okay.
file an application for leave to appeal
Mhm.
the Court of Appeals decision, and the Supreme Court has to grant leave to appeal. Because it is such an important issue, the Michigan Supreme Court very well could grant it. In other words, it's more likely in this case that it would grant it than in the normal case. For example, the Andrews versus Alter case, this acquiescence case, if the aggrieved party applied to the Michigan Supreme Court, it's unlikely that the court would grant leave, because the principles are well established in the state of Michigan. The decision that we have from the Supreme Court is Bolt versus City of Lansing, which is the law of the land. Now, maybe the Michigan Supreme Court, in its current, with the current members, wants an opportunity to revisit the Bolt decision. I don't know the answer to that, but it's certainly possible that the Michigan Supreme Court would grant leave to appeal. Who knows? But
Is it possible that a municipality might be willing to I don't know, stay with what the law was determined, but because it is such an important case that other municipalities might all come together and want to take it to the Supreme Court?
yeah, well, you have what's called amicus curiae, which are friends of the court, and so I would certainly expect that if the decision is appealed to the Michigan Supreme Court, that the Michigan Municipal League, the MTA, Michigan Township Association, they might actually join in or file amicus curiae briefs in support of the municipality. That's certainly a possibility.
Despite what the municipality may or may not want to do?
Yeah, they have the right to apply to the court, whether the city of Jackson wanted the amicus briefs filed or not. They have the ability to file them. And the same thing, like the Michigan Association of Realtors often gets involved in issues of significance, and they may seek to file an amicus brief on behalf of the private property owners.
Okay. All right, well, enough said on that issue.
Yeah.
Until next week.
Till the 11th.
There you go. We'll be talking about it at our council meeting on the 13th. So, we have a price reduction on 301 Ridgeway, and it is down to $64,500. It's a really cute 2-bedroom, 1 bath, 870 square 400-foot house over there in the East Jackson School District.
Ridgeway.
Ridgeway, just off of East Michigan Avenue, east of 127.
Oh, okay.
So, cute little area, easy to get to the highway. And with that said, we just have the Amazing Race coming up, so we need sponsors, we need teams, and it's going to be a lot of fun at the party, 5 to 9. You're going to be there, correct?
Probably.
Randy Rozak and the High Notes on their farewell tour are playing, and Julie Taluki from the Oak Tree Lounge is doing the food. We'll have a hospitality tent. We've got Comerica is sponsoring, and Derek Dobies, my fellow council person, American Title, a whole list of people. Jackie will talk about it tomorrow.
We'll have more on that tomorrow.
Cool.
We'll see you next week.
Ciao.